Imagine starting a brand new job with the New Jersey court system excited, hopeful, ready to make a difference. Now imagine within weeks, one of your coworkers starts making inappropriate gestures, sexual noises, and even physical contact with you. You report it exactly like you've been told to do in every HR training video, and instead of protecting you, your employer turns on you. That's what Natalie Spence says happened to her when she worked for the New Jersey court system. And her case, Spence v. State of New Jersey, shows just how difficult it can be to prove harassment and retaliation even when you do everything right. So by the end of this video, you will understand why documenting harassment matters more than most people realize. How even a bad performance review can count as retaliation under Title VII, and what can happen when HR hears a complaint and does nothing about it. But most importantly, you'll walk away knowing what you can do if you ever find yourself in a situation like this. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider, and on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer trying to do things the right way. One of the reasons I started the HR Insider is because of the number of subtle and honestly insidious harassment cases that are out there, because I know how hard it is for employees to prove that their rights have been violated. Even when you do everything right, you report it, you document it, you follow procedure, the system doesn't always work out the way it should. That's why the HR Insider exists, to help you understand what to do when you're confronted with retaliation, harassment, or any violation of your rights at work. I want you to know that you're not powerless, and the case we're talking about today, it's a perfect example of why the knowledge that's shared on this channel matters. Okay, let's get into it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. On June 26, 2017, Natalie Spence started her new job as a judiciary clerk in the Camden County Probation Department, working in the Child Support Division. In just a few days, she says that one of her coworkers, Don Callender, the person assigned to train her, began sexually harassing her. According to her lawsuit, while she was sitting at her cubicle, Callender approached her, stood extremely close, with his groin just inches away from her face, and started asking inappropriate personal questions. He even tried to touch her. Shocked, Natalie reported the incident to her supervisor, Renata Krasnowski, but instead of taking action, Krasnowski told her that Callender wasn't a threat and suggested that she be patient with him. Over the next few weeks, the behavior didn't stop. It got worse. Natalie alleges that Callender would come up behind her while she was filing paperwork and press himself against her, making unnecessary physical contact and blow kisses across the room. Then, at the office's annual summer barbecue, things escalated again. Natalie alleges that Callender made sexually offensive jokes using a hot dog, walked around in his undershirt, straddled a chair in her direction, and while staring straight at her, zipped and untucked his pants while making sexual noises. Each time, Natalie told him to stop, and each time he told her that no one would believe her because she was still on probation as a new employee. After that company barbecue, Natalie reported the harassment again to Renata Krasnowski, but nothing changed. Instead, just a week or two later, Natalie received a negative performance review saying she didn't meet expectations, a report she believes was retaliation for speaking up. She then went above her supervisor and reported the behavior to Cornell Williamson, another manager. Soon after, in September 2017, she was transferred out of the department. She was moved first to an administrative unit and then again to the Burlington County Superior Court. She says coworkers in her new department treated her coldly, as if she were the problem. Eventually, she filed a complaint with the Equal Employment Opportunity Commission, received her right to sue letter, and on December 17, 2019, she brought her case in federal court. After her first lawsuit was filed, the state pushed back, arguing that her claims weren't detailed enough to continue. So, like many plaintiffs do, she went back and strengthened her case. The result was an amended complaint, basically a revised version of her lawsuit, with more specifics and the legal clarity that was needed. Now, that version named 5 defendants: the state of New Jersey, the New Jersey Judiciary, John Callender, Renata Kursnowski, and Cornell Williamson, and she alleged sexual harassment and retaliation under Title VII and the New Jersey law against discrimination. If you've watched my harassment prevention training for New York or at the federal level, you'll recognize some of the principles shared in this case. But New Jersey has its own unique laws for harassment, which actually go further than federal law in some ways. I haven't released a New Jersey specific training yet, but I will soon because this case shows just how important it is to understand your rights under state law, not just federal law. So make sure you subscribe so you don't miss it. When the state of New Jersey responded to Natalie Spence's lawsuit, they didn't dispute her allegations were serious. But to be clear, that doesn't mean they admitted anything happened. At this early stage in the game, the court isn't deciding who's telling the truth. It's only asking if everything the plaintiff says is true, does it still meet the legal standard that's required to move the case forward? So the state's argument wasn't this didn't happen. It was even if it did, it's not enough to prove harassment or retaliation under the law. They raised several counter arguments, and the court took each one seriously. Let's take a moment to walk through those now because understanding how employers defend these cases can tell us a lot about what really happens inside workplaces, how investigations unfold, how conversations are handled, and how those choices can shape the legal outcome later on. First, the defense argued that individual coworkers and supervisors can't be personally sued under Title VII, only the employer itself. And the court agreed. Those claims were dismissed with prejudice, which basically means that Spence can't bring the issue to court again because it's a closed matter. Second, the state argued that even if everything Natalie said was true, the complaint didn't describe enough detail. There were no dates, no frequency, no explanation of how it impacted her work. The court partly agreed. It dismissed the harassment claims without prejudice, giving her a chance to refile with more detail. Third, the defense said there wasn't enough proof that her bad review or transfer were caused by her complaints. And here's where the court had a mixed outcome because the negative review claim survived summary judgment, but the transfer claim didn't. The judge said there wasn't enough evidence of timing or motive. Now, this is where knowledge really matters. The court said there wasn't enough evidence. And this is where documentation becomes critical. Harassment and retaliation cases usually aren't about one big event. They're about a pattern, a series of smaller, even subtle things that when you look at them together, show that someone has become a target. I go into this in much more detail in my video called Covert Workplace Retaliation Explained. So make sure you check that out after this one if you want to understand what those patterns look like and how to recognize them early. Fourth, they argued that the judiciary couldn't be blamed for a coworker's behavior because there wasn't enough proof that the organization knew or failed to act appropriately. And here, the court said the allegations didn't yet show a pattern of inaction, but she could amend her complaint to clarify. And finally, they argued that even if her claims were true, the state had legitimate reasons for its employment decisions, not retaliation. And the court rejected that argument, at least for now. At this stage, the judge said the court can't decide whether those reasons were legitimate without more evidence. So the state succeeded in narrowing down Natalie's case, but not in getting it thrown out completely. Natalie's retaliation claim stayed alive, proving that even when the odds are stacked against an employee, some claims can survive if the facts are strong enough. And if you're an HR leader or business owner trying to figure out how to handle these cases the right way, I've got you covered. Check out my investigation playlist, the free quizzes and policies, and my harassment investigation workbook. It's a step-by-step guide that takes you through the entire process from planning the investigation to interviewing and making a conclusion. Make sure you check it out after this video. It's a great way to build your confidence in handling these cases properly. Natalie Spencer's story is yet another reminder that standing up for yourself isn't easy. You can follow every rule, file every report, and still face backlash, but that doesn't mean your voice doesn't matter. If you're in HR, remember how you respond to complaints. It determines whether your workplace protects people or silences them. And if you're an employee, document what happens, report through proper channels, and don't give up. The law protects you for speaking up. My Retaliation Workbook for employees is designed to help you understand how to connect what's happening to you with the legal protections you already have so you can recognize retaliation. Document it clearly and protect your rights. Even when cases like this one fade quietly into settlement, they still move the needle forward for everyone who comes after. If you found this breakdown helpful, make sure you subscribe to the HR Insider for more real-world cases that reveal how workplace laws really work. I'm Harlow, and remember, knowledge is power, especially in the workplace.